Hello and welcome to this new video. Today we are going to discuss on a topic: can a bill become an act without the governor's assent? Now, why we are discussing this? In a very rare move, the President of India has invoked Article 143 of the Constitution, seeking the advisory opinion of the Supreme Court. To understand this, first let's understand what is Article 143 of the Constitution. Article 143 of the Constitution allows the President to seek Supreme Court advisory opinion. Now, there are two categories for this. First is a pre-constitutional matter, and second is a post-constitutional matter. So, where we talk about the pre-constitutional matter, it is prior to the commencement of the Constitution, where the Supreme Court, in such case, it is binding on the Supreme Court to give the advisory opinion to the President. But when we look at the post-constitutional matter, it is not mandatory on the part of Supreme Court to give the advisory opinion to the President. It is upon the discretion of the Supreme Court to give the advisory opinion to the President. Now, what is the legal weightage of this? The advisory opinion carries a significant legal weightage, but not in terms of precedent, because the President is not bound by the advisory opinion to follow. But it has its own significance, which we are going to discuss it later. Now, let's understand the history of this. So basically, the Tamil Nadu governor has exercised pocket veto over 10 bills which were passed by the state legislature of the Tamil Nadu government. Now, some bills were returned for the reconsideration. To some bill, it was reserved for the President. Now, to some bill which was returned for the reconsideration, when it came back from the state legislature of the Tamil Nadu government, the governor has not acted on the bill while exercising pocket veto. And the President also haven't acted on the bill which was reserved to the President for a very long time. Now, the Tamil Nadu government has reached the Supreme Court regarding this, and the Supreme Court has given a landmark judgment, where the two-judge bench has given the judgment. And why am I emphasizing on this two-judge bench? You will get to know later in this video. Now, there's a time limit which was being imposed by the Supreme Court, which is 3 months for the governor. And if the governor sends the bill back to the state legislature for reconsideration, and if the state legislature again passes the bill to the governor has to give assent within a span of 1 month. Now, if the governor failed to give the assent within the stipulated time period given by the Apex Court, now you can invoke Article 32, you can reach the court, and the court can issue writ of mandamus to the President or the governor to give assent to the bill. So basically, this is overreaching of the Constitution. You are snatching the constitutional discretion on part of governor and President. Now, using Article 142 of the Constitution, which allows the Supreme Court to pass any order to do complete justice. Now, in this particular judgment, the Supreme Court has touched the two aspects. Number one, the 10 bills which was not formally assented by the governor and the President. The Supreme Court declared it as valid laws. What it means that without the formal assent of the governor or the President to which the bill was reserved, without their assent, the Supreme Court declared it as valid laws. Second, the Supreme Court stated that when the governor reserves a bill for the President has to come to the Supreme Court, ask for the advisory opinion under Article 143 regarding the assenting of the bill. So basically, every time governor reserves a bill on part of President, the President has to seek the court permission for assenting the bill. This is what we call as judicial despotism, judicial overreach, or judicial activism, depending upon which side of the debate you are. Now, what are these 14 questions which is being asked by the President to the Supreme Court? Let's discuss it one by one. Now, what are the options available on part of governor under Article 200 of the Constitution? Either the governor can give the assent, or the governor can withhold the assent, or the governor can, while withholding the assent, send the bill back to the state legislature for the reconsideration, and the governor can reserve the bill for the President under Article 200. Please clarify this Article 200 options, because you seem to have rewritten the Constitution. Question number 2. Whether the governor is bound by the aid and advice of the Council of Ministers and Chief Minister. Because if that's the case, then there is no need of constitutional discretion under Article 200 of the Constitution. The Chief Minister of the state and the Council of Ministers of the particular state is advising the governor to act on the particular bill, to not to give assent or to give assent to a particular bill. So if that's the case, if he has to get bound by the Council of Minister aid and advice, then there is no need of constitutional discretion under Article 200 of the Constitution. Question number 3. Is the exercise of the constitutional discretion by the governor under Article 200 of the Constitution of India is justiciable? Can the courts really sit over the judgment of the governor's discretion over to assent the bill or not to assent the bill? Are we going to judicially review the governor's discretion? Please clarify on this. Now, question number 4. Applicability of Article 361, which talks about the immunity of governor and the president. So here, the president is asking, while discharging the duties, the governor and the president decisions cannot be challenged before the court of law. This is a judicial bar on part of Article 361. If that's so, that isn't that constitutionally barred, then how can the inaction or the decision taken by the governor or the president on part of bills are getting questioned in the court of law? Long story short, if Article 361 provides for immunity to both the president and the governor, how can their inaction or decision to assent to the bill or not to assent to the bill are getting questioned before the court of law? So isn't that constitutionally barred? Please answer this. Question number 5, which talks about imposition of time limits by the courts. Now, where in the Constitution, when it is silent on the time limits under Article 200 of the Constitution, then you are imposing 3 months' time, 1 month's time. Are you trying to rewrite the Constitution? Please clarify on this. Now, going to question number 6. Is the exercise of constitutional discretion by the president under Article 201 of the Constitution of India is justiciable? Now, under Article 201 of the Constitution, the president may either assent to the bill, withhold the bill, or direct the governor to send the bill back to the state legislature, and within a period of 6 months, the state legislature can reconsider it and send this bill back again to the president. Now, after that, what president will do? The Constitution is silent on this. So if the Constitution, in the absence of this Constitution clarity, wasn't that left to the president discretion deliberately? Answer this question. Coming to question number 7, I already told you that the Constitution is silent on time limits, either in part of governor or in part of president. So how can you impose time limits on president too? Please answer this question. Question number 8, whether the president must consult the court under Article 143. Now, I have already discussed this with you. With all the time when the governor reserves the bill for the president has to invoke Article 143 of the Constitution and has to reach the Supreme Court and take the permission of the court either to assent the bill or to withhold the bill. Is it not constitutionally barred? Are you trying to bypass the constitutional framework? Please answer this question. Question number 9. Can the Supreme Court adjudicate on a bill before it becomes a law? The question is no, because the Supreme Court doesn't believe in hypothetical judicial review. So basically, a bill may not become a law. So are you trying to say that the judiciary can step in and review a bill before it becomes a law? Please answer this question. Question number 10. Under Article 142, can the constitutional power of the president and the governor be overridden by using Article 142 of the Constitution? Are you trying to bypass the constitutional framework? Please answer this. Now coming to question number 11. Now I have earlier discussed with you when the court was giving this judgment, it have decided that the 10 bills which were being presented before the governor or the president, to which the formal assent was not given by the governor and the president, it has been deemed to pass as valid laws. So the question here is, without the formal assent of the governor or the president, can a bill become a law? Question number 12. Well, the Supreme Court says that we are not trying to rewrite the Constitution. Since the Constitution is silent on the time limits, we are interpreting the Constitution. So for the interpretation of the Constitution, don't you think there should be a constitutional bench set up? Because if you remember, I have mentioned a 2-judge bench. So this particular matter was adjudicated by 2 judges. This matter was decided by 2-judge bench, to which it should be decided by the constitutional bench, a 5-judge bench. Don't you think this is not constitutionally valid to interpret the Constitution without a constitutional bench? Please answer this question. Question number 13. What is the scope of Article 142? Because there has to have a limit on Article 142. Because it cannot be used as a nuclear missile. So, especially when it used to, override the constitutional limits. Please answer this. Question number 14. When there is a dispute between the center and the state, is there any other option other than Article 131 of the Constitution? Now, these are the 14 questions which the President has asked the Supreme Court. Now, we have to wait for the response of the Supreme Court. What do you think about this? Is it a judicial overreach or just interpretation of the Constitution? Share your thoughts in the comments below. Jai Hind.